Thanks for coming out today to listen about copyright and hopefully to share your own thoughts. I'll leave plenty of time at the end for your questions and comments. I hope to offer you a perspective on copyright that you might not often hear here on the Hill. It's framed around, as you can tell from the title, a view of copyright that is in contrast to what you usually hear, in that copyright is usually described as a type of property. It's described as a type of intellectual property. And in this book, I explore the idea that instead we should view copyright as a government-granted privilege. Now, please understand, that doesn't mean I'm anti-copyright. The government does a lot of things in the line of granting privileges that have lots of fans. You know, farm subsidies, federal welfare, all sorts of things which may or may not be a good idea depending on the cost-benefit calculations that you run. And I simply take the view we should approach copyright the same way. That's in contrast to some of my friends, especially on the right, who when they hear the word property, kind of stop analyzing. I'm afraid they've been, frankly, bamboozled a little bit by the rhetoric of intellectual property into not casting a critical eye on copyright. So today I want to explore with you some things from my book. I'm going to share with you some of the many images, the graphics, the charts from the book. They give us a quick way to walk through the main thesis, and it's better than putting words up on the screen, although I have a few of those. Before I get started on that, though, let me draw a contrast between copyright and some other types of so-called intellectual property, just so we're all on the same page here. I know not all of you are maybe intellectual property geeks like I am, so let me just quickly note that traditionally 4 things are included under the title of IP. We have copyright, which we'll talk about today, patents, which are kind of their close kin. They're both protected in the same constitutional clause, copyrights and patents. And then 2 other things which I won't have much to say about today. In fact, I won't say much about patent either. Trade secrets and trademarks. So what's copyright? Copyright's the thing we're going to talk about today. Copyright of those 4 is the type of IP that protects fixed expressive works. Novels, movies, songs, sculptures, paintings. They're basically works of art, although it also includes useful things like programs and maps and charts. You might wonder, well, isn't that the proper subject matter for patent? The way it's treated in the law is that a map reflects choices made by an author, right? When you make a map, you have to decide, I'm going to make the rivers blue versus green, or I'm going to make the names of cities so big. Now, this is not great art, but it does show that there's some discretion by the creator, and that's all it takes for copyright. As long as it's a fixed, original expression of authorship, you qualify for federal copyright protection. So I just want to clarify, that's what we're talking about. I won't have much to say about patents, trade secrets, trademarks. I'd love to talk about those, but we won't do it today. Let's talk about what I do talk about in the book. So I want to start out by saying to you, I'm offering a free market view of copyright here. It's not the only free market view of copyright. Indeed, as I've said, many of my friends on the right have a different view of copyright, and I like arguing with them about this. They are my friends, and I have friends on the left too. This is the traditional, I'm generalizing here, but the traditional left-right spectrum as applied to copyright. I'm generalizing. I don't want anyone to take offense if they think I've pigeonholed you, but I think there's a lot of truth in these generalizations. And very generally, I see on the left people questioning copyright restrictions. They basically are a little skeptical of copyright. They're a little worried about copyright. Why? Because, like me, I agree with them on this, they view copyright as a restriction on freedom of speech. And that it is. I don't think people really reflect on this enough. Let me give you an example of how this is a really concrete effect. Martin Luther King's I Have a Dream speech, it turns out, is protected by copyright. And the copyright happens to be owned by the British conglomerate EMI. So if I were to walk out here on the steps in front of the building and to make a political statement, start reciting MLK's speech, in theory at least, I would be infringing on the copyright. Now, those of you who are familiar with copyright might say, oh, but Tom, you'd be protected by fair use. And I'd say, that's not so clear. Those of us who work in copyright know that fair use defense is notoriously vague. And if I get it wrong, I'm liable for $150,000 in statutory damages, potentially at least. EMI could walk up to me and say, Tom, you just recited the whole speech. You didn't just paraphrase it. You didn't just do a quote, the whole speech. And I say, I had to get the full impact of MLK's words. They could bust me because they own the copyright. Kind of nutty, isn't it? More than nutty, though, that's a restriction on my free speech rights. And this is something I really worry about, and I wish people would think about, because it's easy for those of us who maybe are more comfortable with creating our own words to think, oh, it's easy. You create your own paraphrase. I mean, I look around the room and I think, all these people, super smart, creme de la creme. Somebody says to you, write me a speech, come up with a position paper, boom, you do it, no sweat. Your own words, it's beautiful, it's effective. Joe Sixpack, Jane Sixpack, they don't have that. Let's reflect on that. They have to borrow other people's words to make their points. And we are taking from them the ability to do that to the extent we use copyright to restrict them from borrowing other people's words. So somebody says, man, that MLK speech, that really moves me. In fact, I want to play it here today. They say, I can't really do justice to MLK's presentation. I got to play that DVD. That's really a good point. Even if I recited MLK's speech, I'm not going to do it the same way as the man. So I want to play the DVD. Busted. Okay? For a lot of people, that's the only way they're going to be able to convey their most heartfelt views. That is definitely a restriction on speech. And of course, the Supreme Court's considered this, and they've basically given a pass to copyright, and I have some problems with that jurisprudence. So my friends on the left worry about that, and yay for them. I agree with them on that. My friends on the right are pro-property rights, and so am I. I'm a big fan of tangible property rights in lecterns, in cars, in houses. I really am a fan of property rights, and I think we should take them seriously. My friends on the right, we share that. I'm totally square on with them there. So I got friends on both sides. Where do I disagree with people? I find on the left sometimes people have a too flexible view of property. They say, oh, there's not any natural right to property. It's just, it's just a tool for politicians to tinker with so they can get things just right. So yeah, copyright's a form of property, sure, and we can change it as we see fit for the public good. Oh, and ditto, by the way, your property right in your house. If we decide, yeah, whatever, you get to have it for 20 years and then we're going to give it to somebody else, we passed the legislation, we're done here. It was for everybody's good. And I go, whoa, no. There's a natural right to tangible property. That kind of makes me a loner in academia to have that view, I admit, but I'm willing to be alone on that. And even if you don't agree with me on the natural rights view, there's a common law right to tangible property. That you can't say that of copyright. There's no common law right to copyright. So my friends on the left, I say, I think you should distinguish between tangible property rights respected in a state of nature and a common law, and then copyright, which is really not property at all. And where do I disagree with my friends on the right? Well, I think, as I said, I'm afraid they've been a little fooled by this rhetoric of property. They say, yeah, we like property, and oh yeah, I guess copyright, they call it intellectual property, that's property too. Well, I better go to the ramparts for that. And I want to say to my friends on the right, let's rethink that, because I'm all for property rights, but I see copyright as different. It's a government-granted privilege versus our property rights in lecterns and houses and cars. Those exist in a state of nature and a common law, and they deserve special treatment. Now, this is a little philosophical for you, but I did think it was important to lay this out. The book is in part philosophical, but later I'll show you it's not just, ivory tower theorizing. I actually have in here some specific legislative proposals, which I'll share with you in a little bit. So here's where I end up on copyright. I view copyright from the point of view of I'm pro-property rights, and I'm willing to question copyright restrictions. I call them copyright restrictions. Some people say copyright protections. They do protect some people's positions in this world, but I view them as from the point of view of someone who worries about free speech rights, and indeed, I'll say, property rights. Because when you enforce a copyright, how do you do that? You're restricting someone else's property rights. You're saying, you can't use that DVD the way you want to. You can't use that projector. You can't use that guitar. You can't use your throat, your own throat. You can't use your own throat in the way you would like to. And so it's a restriction on your property rights and your freedom of speech. And that worries me, and I think we should all think a little more carefully about what copyright does. Now, the subtitle of the book is Copyright, Common Law, and the Common Good. And I'm a big fan of the common law, and I'm going to very quickly explain to you why I like the common law. It's a very complicated topic. Unusually for a law professor, I teach all the big three common law courses: property, torts, and contracts. I've taught all three. I'm such a fan of common law. Well, I don't have to tell you guys, because I'm sure you're familiar with this, but I'll walk through it quickly. What is a common law? It's actually kind of complicated. People really debate what the common law is. My quick view is, the great thing about common law is it comes from the bottom up. You can see on this chart that the common law begins, at the very beginning, the common law arose in the everyday practices of people in the markets, in the fields, in the streets, and courts originally would bring witnesses before the court to say, well, how do you resolve the sort of dispute we have before us today? How do you resolve that in your community? And so they would discover the sort of practices that had evolved. This is back in England in the late medieval times. They'd look at how the solutions people had actually worked out on their own. So this is a bottom-up solution to the very vexing problems of how to allocate rights in a complicated society. And this is very different from legislation. There's room for both, but let's note the difference. The common law comes from the bottom up. Legislation comes from the top down. We expect a few really smart, dedicated people like yourselves to figure out hard problems and write down the solution. That's legislation. And then you say to whatever your jurisdiction is, here, Washington, the whole of the United States, here's how to do it, people. Follow these controls, follow these limits, or you'll be in trouble. The common law is different. It comes from the bottom up. You can see there's this kind of complex interaction between what courts and commentators do. First, we look out there in the world and we say, how do people in the world actually behave? Do they respect, boundaries put up by fences? They do. We're going to do that. We're going to recognize that in our court. And then commentators like Bracton or Cook or the restatements of the common law, some of you went to law school familiar with that, commentators look at those court decisions and kind of sum them up and say, oh, well then here's the tort of battery. It's a non-consensual offensive touching. And this is something they draw from many different cases. You read lots of cases and you say, well, here's the general rule I see. And of course, the influence goes both ways. Once a court issues a decision, people read the court decision and they say, oh, well, this is what the court says we ought to do, so let's resolve our dispute per that court decision. So these things interact in a complicated way. You can say, oh, that's muddy and confusing. I think it's a beautiful tapestry. It's complex, it's resilient, it's adaptive, and it's just different from legislation. I think it has a lot of advantages that are unappreciated. I draw this contrast because I want us to think about how legislation works. You guys know better than me because you're here on the Hill. But I've been told, and I believe, and I'm sure you can testify to this, that lobbyists have a big influence on legislation. And I think this is especially true in copyright. And this is just one illustration of how copyright has changed over the years. I'm going to offer you some more, but this is just a quick look at how the copyright statute has changed. The first Copyright Act came out in 1790. Now note that date. 1 year after they ratified the Constitution. So the same guys, and they were guys, the same guys who ratified the Constitution basically passed the first Copyright Act. It was in the first Congress, one of the first things they did, in fact. So they passed the first Copyright Act, and how did they do it? Man, that is lean and mean and clean. That's about twice the length of an op-ed. That's all it took them. And they had, right there, boom, the first Copyright Act, 1790. What's it look like today? Well, this is actually a very conservative count. On some counts, you can get up to over 130,000 words in the Copyright Act. If you look at all the statutes administered by the Copyright Office, and I'm not here, by the way, including all the various circulars and regulations the Copyright Office issues. This is just the statute. So, wow, we've seen a lot of increase in the words of the Act. Now, you might say, Tom, that doesn't really prove much. What matters is the content, right? I mean, maybe the 1790 Act said, you get your head chopped off if you infringe copyright, and now we have this very subtle, gentle approach. Well, let's look at some more evidence. Because it turns out we have more than just the number of words to suggest that, in fact, public choice pressures, that is to say, the influence of lobbyists, have kind of pushed copyright out of balance. That's what I would argue. This is the duration of copyright. Now, with regard to the present duration here, I've made kind of an estimate of the present duration because why? Because the current copyright term for individual authors is in fact life of the author, or really death of the author, plus 70 years. And so, of course, how long a copyright lasts depends on how long an author lives, and I made a conservative estimate that you have an author who at age 35 creates a work and lives till 70. So you get basically, 35 years plus another 70, you're well over 100 years. That's a lot more than the founders had in mind. The founders only allowed a maximum of 28 years, and in fact, they broke out copyright into two 14-year terms. And one of the things I've done with this book, I'm such a huge fan of the founders. I respect them so much. I've even decided to grow my hair like the founders. I'm not going to go to a wig unless it's necessary. So far, so good. No tricorn hat for me. But I'm such a big fan of the founders that I've released the book with Mercatus's permission, and they went along with me on this, under the 1790 Copyright Act. You can see the second page here, this copyright notice. It was in my contract with them. I said, guys, you got to let me do this. And basically, this book is going to fall into the public domain in 28 years. Because if it's good enough for the founders, it's good enough for me. We may even put it in the public domain after 14 years because there's this interesting problem in that, well, in fact, the 1790 Copyright Act provided for a 14-year term, and then they had this administrative process to renew the copyright, and we don't have the machinery to do that anymore. So I don't know, we'll work that out in 14 years. So the 1790 Copyright Act, maximum term of 28 years, and then in the 1831 Act, they bumped it up to 46 years, and then later they bumped it up to 42, and then up to 58, and so on and so forth. Up and up and up and up and up. Now, why has this happened? It'd be nice to think that lawmakers very carefully calibrated the term of copyright. You know, they went out there and they collected evidence and they said, oh, you know, we need just 12 more years. That's going to, oh, perfect, right there. Not 13, not 11, 12. And then they revisited it later and said, oh, and now we need a little bit more because things have changed. I don't know, maybe it happened that way. I doubt it. I think, in fact, what happened was basically your typical public choice effect. Public choice theory tells us that when you have concentrated benefits, someone like, oh, say, Disney, showing up and saying, you know, it would be great for us if Steamboat Willie didn't fall in the public domain. Concentrated benefits, diffuse costs, when they extend the term of copyright and keep Steamboat Willie from the public domain, in a way that costs all of us just a little tiny bit. Because, you know, maybe I wasn't going to do anything with Steamboat Willie, maybe I was, maybe I'm an artist, I was going to do something with it, and now I can't. I don't weep about that. I don't lobby about that. And so what you have happen is Disney shows up and says, hey, increase copyright. And if you're a lawmaker, you say, okay, let's hear from everybody. Anybody really care about the other side of this issue? Really, until recently anyhow, there hasn't been a lot of weight on the other side. And I think legislators are basically doing their jobs. They're listening to people who come to visit them, but it's just a one-sided process because the costs of copyright's growth are largely diffuse, the benefits are concentrated, so you hear from the beneficiaries, and so you get more and more and more copyright restrictions. So this I've illustrated graphically. This is another chart from the book. This I call the Mickey Mouse curve. So what's going on here? So Steamboat Willie's released in 1928. And initially it's released under the 1909 Act, maximum term of 56 years. And, you know, it starts running out. As soon as that red dotted line crosses the horizontal axis, Steamboat Willie falls into the public domain. And it doesn't happen. Now, I wasn't here. I don't even know if Disney showed up. But it is instructive that, oh, look at that, Steamboat Willie's getting close to the public domain. Oh, well, look at that. The copyright term got extended. Well, okay, that's good for Disney. Oh, it's starting to expire again. Boom, it gets bumped up again with the Sonny Bono Copyright Extension Act. And right now it's slated to run out before 2030, and well, we'll see what happens. I think we can make a prediction there will be some pressure to again extend copyright, whether it's Disney or somebody else. Disney's not the only party with copyrights that are expiring. Is that good or bad? Well, I will tell you that I'm not sure it's a balanced view of copyright. People talk about copyright being in delicate balance. I don't see that. I see all the pressure going in one direction. And I think that's a problem for everybody. So let's talk about some other ways that the Act has changed. We have the Founders Copyright, the 1790 Copyright Act. Again, that's how we've released this book. And it's not just the term that I've given up by releasing this under the 1790 Copyright Act. It's kind of a proof of concept. I want to show people that, hey, you know, the 1790 Copyright Act was pretty good. It was good enough. Maybe we have more copyright now than we need. So certainly the term, I've already talked about that, maximum term 28 years. Currently, for an author like myself, an individual, author's life plus 70. If it's a work for hire, like Disney's works would be today, you could have a term of up to 120 years. It's more complicated than that, but it could be 120 years. So terms gotten longer. What else? The ways that you get in trouble have changed. They become much more broad. The 1790 Act, the Founders Copyright, basically only forbade exact copies, what we call piracy today. So I suppose I could bust somebody. I'm not sure I'd really care much, but if somebody like made a photocopy of the whole book and started selling it. By the way, I'm not getting any royalties from the book either. That's the deal I worked out with Mercatus. I said, guys, you go along with me on this crazy 1790 copyright thing, you can keep all the money. I don't care. You know, I'm already paid. I'm an academic. I just want to get my ideas out there. I'm so happy to have you listen. But under the present Act, certainly piracy, complete copies, that's a verboten, but also preparing derivative works, public performances, public displays, public distributions. Here's what you can do with my book that you can't do with MLK's speech. You can create a derivative work. You can create a musical of my book if you wanted. Go ahead. I will not be able to stop you. You could create a translation. I think it'd be wonderful, actually. If you want to create a German translation, have at it. You want to publicly perform it, stand up and read it in front of a crowd? Yay. I got nothing to say about that except thank you very much for spreading the good word. All that stuff's forbidden today. So it's not just the term of copyright that's changed. What about the subject matter? Now this is very interesting. The founders protected only maps, books, and charts. That's it. Basically, any fixed expressive work today is covered by copyright. All this stuff here, sculptures, paintings, sound recordings, computer programs, even grocery lists. Some of you might be like taking notes. You're jotting down things, or maybe you're doodling on a piece of paper as you're listening. That is a fixed expressive work. Conceivably, you have a federal copyright. Now, the founders knew about songs and plays and sculptures and paintings and prints and architecture, and they didn't protect it. And why is that so instructive? Well, there's this view that copyright is a natural right. My friends on the right sometimes have this view. They say, I like Locke's theory. Locke says if you go out in nature, say, and you collect acorns, you mix your labor with something you find in a state of nature, you own the thing you mix your labor with. And my friends on the right, my fellow philosophers, Lockeans, say, well, the same thing applies to copyright. If I sit down at my typewriter, or these days keyboard, and I start typing a novel, I'm kind of mixing my thoughts with this noumenal realm of ideas. And so it's just like I go out and I collect acorns. That's what Locke talks about, collecting acorns in the forest. I've mixed my labor with the acorns, now they're my acorns. Some people argue the same thing with copyright. They say, I mix my efforts with this noumenal realm of ideas, and now I own the novel in the same way I own acorns. Well, I don't think the founders had that in mind. The founders knew about Locke, and they knew about paintings and sculptures in general, artistic creation, and if they really had a natural view of copyright, a natural rights view of copyright, they would have included paintings and sculptures and songs and everything else in the subject matter of copyright. But they didn't, and why not? For one thing, they did not have a natural rights view of copyright. That's one reason. I think they viewed it as strictly a utilitarian device to help their nascent country grow strong. And they worried about giving the federal government too much power. They were actually quite agonized over copyright. Jefferson wrote to Madison from Paris, where he was serving in a diplomatic capacity for the United States. And he had a draft of this Constitution, and he wrote to Madison saying, I'm not so sure about this copyright thing. I mean, didn't we dislike monopolies that were enforced on us by the English? And Madison wrote in reply kind of an apology to Jefferson, saying, you know, I share your concerns, but I think, you know, we keep this tightly constrained, it'll be okay, it'll help the public overall. Madison did not say, Tom, it's a natural right. I don't think they looked at it that way. They were worried, they wanted to keep it to the bare necessities, and so they looked around their country and they said, what do we need here? Do we need sculptures, paintings, songs? Love that stuff, but that's not the issue here. We need maps and charts, so we know where to go, where the shoals are when we're sailing, and we need books because why? Well, think about this. The founders really didn't know about novels. I've researched this. It's quite interesting. The novel is kind of a recent invention. It was the first novel actually is about contemporaneous with the first Copyright Act. When the founders were thinking about books and they looked at their own libraries, what did they see? They've actually studied this. People have gone back and they've looked at the libraries from the era and they've kind of cataloged what kind of books were there. Not novels, because that was a new innovation. There's a lot of scripture, interestingly. I can imagine the founders saying, we need our people to know about God and His Word. So they liked scripture. There's a lot of, collections of sermons and things. And a lot of educational tracts, things like here's how to grow wheat in an arid climate. Here's how to till your soil. Here's how to have big fat cattle, what to feed them, stuff like that. And the founders said, man, that's what we need. We need to protect maps, books, and charts. Painting, sculptures, stuff like that. They weren't Philistines. They loved the arts. But they saw this as sort of bare minimum, what we need to get this country going. So there you go. I think it's very instructive. The founders had this very narrow view of copyright. Happily, I am able to use the 1790 Copyright Act for this because it is a book. I guess I should wonder whether or not some of the drawings in there are protected, but what the hey, have at it, people. What about remedies? Well, the founders basically only had two things going on. If you infringed a copyright, and remember, only maps, books, and charts, only 28 years, only exact copies. If you get caught, what happens? They grab the copies and they destroy them, and you have to pay statutory damages of 50 cents per sheet. They're thinking of, you make 100 copies of a map. You have to copy the whole map, not a derivative work. Make 100 copies of the map. Then you're going to, owe 50 cents for every copy. What do we have now? It's pretty serious stuff. Potentially, your statutory damages under the present act are $150 per infringed work. So if I were today, one of you, I happen to know it's your birthday, and I decide, hey, everybody, let's sing happy birthday. That would be infringing because there's a U.S. company, Campbell, is it Acuff? Campbell Acuff claims a copyright in the Happy Birthday song. And my performance here would basically be a public performance because I'm beyond a small circle of my family and friends. And it would be a public performance. $150,000 potentially is what my liability would be under the statutory damages provisions. Alternatively, I could get sued for actual damages and unjust profits. Probably they'd go for statutory damages in that hypothetical. Destruction of infringing copies and devices, costs and attorney's fees, borrows and incurs fines and imprisonment. There's actually more remedies here, such as the power to subpoena digital service providers to uncover the identities of infringing parties. There's even more stuff you can do. There's really a lot of stuff that you can use against infringers today. I've actually researched this looking for, over the history of copyright, did they ever dial it back? Well, they did codify fair use at one point, although I'm not sure that really reduced copyright, because remember, the case law was already there. Lawmakers simply said, let's write it down in the statute so people know what fair use is. The only thing I found is once Congress passed a bill putting into the public domain the designs of stamps. That's the only place I found where lawmakers dialed back the scope and remedies of copyright. They said stamps are in the public domain, but I got a funny story for you about that. You know, my last name's Bell. And they used to make this forever stamp that had a picture of a bell on it. It said, you know, liberty and forever. And I thought, rockin', I love that. And I used to buy these stamps, and I would, you know, when you buy a book of stamps, they have like the big kind of fake stamp to advertise it. I would take that off, and I'd like, you know, trim it and slap it on my computers. I got them all over my house, you know, it's Bell. And so I decided I'm gonna make a t-shirt, poster. And I call up the Postal Service, and I say, just double checking here. Hey guys, you're okay with me making, you know, poster, t-shirt? Because, you know, that statute I read about. And they said, oh, well, see, actually, now we're a private corporation. So that is copyright protected. So even that one little thing they gave us is now gone because the Postal Service says, I'm not sure they're right about this, I'm not going to litigate. But they said, no, that doesn't apply to us anymore because now we're a private corporation. So there you go, we're back where we were. All right. So there's some ways that copyright has gotten bigger, 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 bigger. People talk about copyright being in delicate balance. I'm a little worried that it's not. I'm worried about it being kind of out of balance. And so in the book, it's not all complaints. You know, I don't just complain about copyright again being bigger and bigger. I do have some complaints, but I want to fix it too. I think it is fixable. And so I make two specific suggestions. I'm going to briefly talk about these. I don't want to bore you to tears. I suppose this is what you guys are looking at 2 or 3 o'clock. You're going to go back and sit at your desks and look at this kind of stuff. So I got a couple, you can get the book. I got a couple of specific provisions. And one of them is codifying copyright's misuse doctrine. Now this is really interesting to me. 107 right now has the fair use doctrine. It's kind of a catch-all defense to copyright infringement where you're able to say things like, well, yes, it looks like I infringed, but in fact I didn't because it was for an educational purpose and I only used part of the work and I didn't harm the market for the original. And it's a multi-factor balancing test. It's notoriously vague. I get emails all the time. People writing to me saying, hey, Professor Bell, you're an expert in copyright. Can I do this? Is this fair use? And I always have to say the same thing. One, I'm not going to give you legal advice because then I'd create an attorney-client relationship. And two, nobody really knows. Too bad for you, but nobody can really say. It's a multi-factor balancing test. But anyhow, that's fair use. I thought it'd be a good idea if we built into the Act a codification of the misuse doctrine. Now, what is copyright misuse? A few courts have recognized it. It's very interesting. Here's how it works. Suppose you have a copyrighted work, like this book. I'll give you an example. Suppose I took this book and I wrapped it in shrink wrap and I put on the cover a label, kind of like you used to see when you bought computer programs with, you know, diskettes, and you see now with, you know, click-through licenses. And I said, by opening this shrink wrap, you contract with me to not criticize the contents of this book. And you go, well, let's see what Bell's got here. You tear off the cover, thereby creating a binding contract. And you open it up and you go, well, I don't agree with this. I'm going to write a blog post. And you start typing, typing, typing. I find out about your blog post and I sue you. I sue you for violating our contractual agreement for sure. But those of you who know anything about contract will say, well, what are you going to get there, Bell? I don't know, not much. You got contract damages for that? Probably not. But I also got you for infringing my copyright. Why? Because you exceeded the bounds of the permission that I gave you. So now I'm combining my copyright powers with my common law rights. And I'm combining both of these to get something copyright alone would not give me. Now I'm shutting down fair use. Now that is very problematic. And what courts looking at these sorts of circumstances have said is, you lose your copyright rights. They will enforce the contract, But they say, look, as long as you're engaging, that's misuse. As long as you're engaging in misuse, you don't get to enjoy your copyright privileges. So courts have done this. There's not a lot of holdings. I had to search long and hard to find the cases and read them very closely, but this is what I see courts doing. They say when you combine your statutory privileges with your common law rights and you grab too much, we're going to take something away. And what they take away is the copyright, not the common law rights. Now, why is that so interesting? Because I think what we need to do is not just go after copyright with a machete. Look, it's not going to happen. Let's be frank. The lobbies are too strong, and I don't even want to do that. I actually like copyright. I'm kind of fond of it. I've spent so much time with it. I think it'd be a big mistake to draw an X through copyright. I'm not anti-copyright. But I do think we need to start encouraging people to develop business models and technologies that don't rely on copyright, to get people to kind of stand on their own 2 feet, to use their common law rights to incentivize the creation of expressive works. Now, they're not going to do that as long as they can always rely on copyright. They're going to be, well, I could say lazy, but they're going to be rational. They're going to say, yeah, I'm going to combine my statutory privileges and everything I can get. If I were an attorney, it was my client, I'd say, yes, go for it all. And what this does is it says, you got to choose. And I hope that with this kind of law in place, sometimes people will say, you know, I like my copyright privileges, but infringement is hard to catch, and litigation is so expensive. You know, I think I'd rather use some digital rights management technology and exactly the kinds of license terms I want, and I'll just use contract. And I guess because of this, I won't get my copyright privileges, but that's okay. I can do better with my common law rights than I can with these statutory privileges. And what happens then? Wonderful things, my friends. I really do think wonderful things would happen. I used to work in Silicon Valley, biggest law firm there. I've done a lot of work with startups, and you guys know how it works. Those people come up with new stuff every day. We don't know exactly what would happen, but I can bet you if you turn people loose and you give them the freedom to innovate, and frankly, you give them a little kick in the pants, and you say to them, stop relying so much on copyright. Those guys in Washington got other things to do. You can take care of yourself. Go come up with a new business model, new technology. Do it on your own. They will come up with some great stuff. And now we'll have the equivalent of copyright happening in Silicon Valley, Austin, Texas, all those places out there where people innovate, and it'll take some of the labor off of your shoulders. You guys got other things to worry about. You won't have to hear from lobbyists whining about how they need more copyright. We'll finally have people turning away from Washington for the solutions to their problems and finding their own solutions. I think that's a beautiful thing. I hope you welcome that too. So that's what I think 107B would do. The other specific statutory provision I have here is 301G. And here my concern is that suppose you want to put your work in the public domain. Like I want this book to be in the public domain in maybe 15 years, maybe 29 years. You might worry. There's some jurisprudence out there that suggests that if you then rely solely on your common law rights, a court might walk in and say, you're trying to do with your contract what we should only do through copyright. So we're not going to let you do that with your contract. And I think that'd be a bad thing. Like I just said, I think we should encourage innovators to go create these business models and technologies to kind of create kind of a private sector equivalent to copyright. And so I just want to make sure those people feel comfortable, that they say to themselves, okay, I can do this. If I'm willing to give up my copyright, I can do whatever I want under my common law rights. I can maybe even, you know, I can go ahead and license people and say, don't criticize my book. Good luck enforcing that, but at least you're not going to be going to Washington saying, fix this with the statute. You're going to be out there in the courts litigating with everybody else. And that's what 301G would do. All right, I'm going to take a breath here, and I'll wrap up very quickly and get your comments. One more point I just want to make, and that is, to some degree, I think copyright's becoming less and less important. I know right now, I talked with some people on the Hill earlier today learning about what's going on. I know right now it's kind of, there's some work going on, but frankly, I think, and we should all celebrate this, copyright's becoming less and less important. I think if you reflect on your experience with copyright, you'll see this going on. Let's tell a story about Elvis Presley back in the day, 1950s, Elvis Presley. Now, he's kind of a ham. I play guitar myself. I do coffee shops and stuff. I'm a total ham. I know how musicians are. You know, sometimes you've got to take the guitar out of the hand to get him to stop. So I'm sure Elvis was the same way. He loved to perform. But he, as much as he loved performing and he wanted to get his music out there to the world, he couldn't do it himself. So Elvis, you can see here, this is Elvis's average subsidy. How much Elvis is willing to subsidize the creation and distribution of his work. He's willing to do a little bit. He'll pay for his own guitar. He'll maybe pay for his bus ticket to Memphis so he can play a few shows. But pretty quickly he hits a wall and he discovers, I can't reach the world on my own. I need copyright, basically. And that's what we see here. As much as Elvis is willing to subsidize his own copyright productions, he can't do it on his own because in the 1950s to create a recording was super expensive. You had to have cutting-edge technology. To distribute the songs to the world, very difficult. You had to ship around physical LPs. They didn't have FedEx. They didn't have the they didn't have the internet. It was very expensive. So hams couldn't have done it in Elvis's day. We probably had to have copyright to have Ain't Nothing But a Hound Dog be a worldwide hit. So yay copyright. But yay technology. Because now someone like Elvis doesn't need to go to Memphis, doesn't need to book time in an expensive studio. Someone like me with a laptop, maybe $2,000. You buy a laptop, GarageBand, internet connection. You can do everything Elvis used to do. Very cheaply, very easily. So effectively what this means is it brings down the average costs, it brings down the marginal costs, and today that's why you see people in their garages, people at their desks creating pop hits that reach the world, just like that, just like that. So copyright in that world, we don't really need it. Not as much. You think about the music we have today, the photographs, that's another area, writings. I mean, you want to read some journalism? Go read a blog. Totally free as long as you have an internet connection. Maybe you watch some ads. So basically, technology has made copyright less important because it's lowered the costs of creating and distributing copyrighted works. So copyright is becoming less and less important. Now, I'm not anti-copyright, and I do worry about a few areas in particular where if we got rid of copyright, we wouldn't like the results. For example, big budget movie productions. Would they have made Captain America without copyright? I kind of doubt that. It was an okay flick. I think we'd be worse off if they didn't make that film. Not maybe great art, but it was entertaining. Also, huge programs like, say, Halo. I mean, millions of person hours go into making those software packages. I don't think hobbyists are going to do that. But increasingly, for a wide number of works, probably musical works, writings, journalism, books, photographs. You go online. I was talking with a photographer yesterday. He used to be a professional photographer, and he said, you just can't do it anymore. He was unhappy, but he understood. He said, I get it, man. You want photographs, it's free. You go online, it's there. So he's, it's unfortunate for him, but we all are better off. So that's where we are with copyright. And I'll just give you an example, because it kind of aggrieves me that copyright covers Happy Birthday. In fact, I think Steamboat Willie, the copyright claim there is bogus. And I talk about that in the book. I also think the copyright claim in Happy Birthday is bogus. And so that kind of hacked me off. I thought, here's some people using copyright. They say it's worth $2 million a year, the licensing fees from Happy Birthday. A chain like, say, Chili's would take out a license so they don't get sued so that their waiters can sing Happy Birthday. Some restaurants come up with alternatives to Happy Birthday so they don't have to pay the licensing fee. And I decided, you know what I want to do? I'm going to create, this is dedicated to the love of my life. It was her birthday, and I wrote this song, and the kids performed it. You can find it online. And note what I did here. This is the way that I've marked this. It's in the public domain. So I figure if I can get other people to use this, the people at Mercatus don't want me to sing this now, so I won't. But I'll do it for you later if you want. So I think it'd be wonderful if I could give people an alternative to Happy Birthday. I think it's kind of sad. People want to celebrate a day with their friends and family and express their love, and then here comes copyright with a big club. That's just not right. So I think you'll see this increasingly. Maybe not this song is the best example, but it's the one I have at hand, but I think you'll see more and more people saying, look, I don't care. I don't care. I don't need copyright. That's not what I'm in the game for. And you'll see people putting stuff in the public domain. And we'll all be better off for it. We don't need copyright. We don't have all those legal problems. You guys have less lobbying to worry about. I think we ought to encourage that kind of world that's coming, and we should welcome it. And I want us to get there, as quickly and easily as possible. So those are some thoughts I wanted to share with you. I thank you so much for listening. I'm going to stop now and see what you have to say. If you have any questions or comments, and there's copies of the book there. And if you want me to sing later, after I'm officially done, I'll be happy to do that. Thank you. Yes?